In the matter of DISHA Kapoor versus State of Uttar Pradesh, Supreme Court dismissed the SLP and said that the petitioner had taken contrary stands and that there were inconsistencies in the complaint and statement which was made before the magistrate, which persuaded the Supreme Court to find proceedings to be a clear abuse of process of the court, as has been held by the High Court in this case. A disgruntled wife was the petitioner in the SLP, aggrieved with the invocation of Section 482 of the Criminal Procedure Code 1973 by High Court of Allahabad to quash a proceeding initiated by petitioner under Section 156(3) of CRPC. The marriage on 11 December 2019 was admitted by the parties, which, according to petitioner, was initiated and carried out with much pomp and ceremony by grandfather of groom, a very respected person who had also been governor of a state. Petitioner alleged that while grandfather of her husband was alive, she was treated with dignity. As soon as he died, mental and physical harassment commenced, not only from husband and his parents but also from larger family comprising of two brothers of father-in-law who were also very influential and one of them holding a minister's post in the government. Complainant accuses her in-laws of having thrown her out of matrimonial home on 28th of September 2020, before which she was beaten up, resulting in a fracture on her hand. Despite being thrown out, complainant, in an attempt at rapprochement, went back to matrimonial home on 8th of October 2020, at which point she was also badly treated and again turned out from the house. An uncle who was arrayed as opposite party minister is alleged to have threatened her with death. The specific threat leveled was that one another uncle would shoot her to death, which uncle was in any case not arrayed as accused in the complaint. Petitioner also spoke of information given to Deputy Chairman of Women Commission who had not taken any action on information supplied. However, there was no record to show proper complaint having been made in writing to Women Commission. Again on 16 December 2021, according to application under Section 156(3), when she went to matrimonial home along with mother, the named persons of family abused her, whereas in statement under Section 200 CRPC, she only spoke of one Subodh Tandon and cousin of husband having demanded a Fortuner car and 50 lakh rupees. Statement under Section 200 CRPC also did not contain any allegation of petitioner having been thrown out of matrimonial house on 28 September 2020. Court said we cannot but also observe that there is no specific allegation of any physical violence except for vague statements made about petitioner having been beaten up in which she sustained a fracture and having been subject to physical and mental torture. There was no evidence of treatment undergone to substantiate the allegation, especially when petitioner was said to have suffered a fracture. Petitioner in affidavit filed in support of written statement before Additional Family Court Lucknow produced along with records indicates that matrimonial life in initial stages was very cordial and even pleasurable, as is stated in the paragraph 6. It was also admitted that statements made by husband regarding visit to clinic of one doctor was intended for counseling and medication prescribed by doctor was to treat anxiety of petitioner not amounting to mental illness, which indicated that relationship had deteriorated in a short span of time. Despite allegation of physical and mental torture as also demand of dowry, petitioner moved family court for restitution of conjugal rights after petition under section 12 was filed by husband. Strangely, it was also stated in affidavit that 50,000 rupees check was given to husband to wife on 26 October 2020 for purpose of purchasing gifts for Karwa Chauth and Diwali. It was also admitted that petitioner had purchased expensive sari which was worn by her on day of Karwa Chauth. According to petitioner, relationship between them was cordial and smooth and there was no tension between them. Statements on affidavit regarding amounts on 26 October by husband to wife for purchase of expensive sari to celebrate Karwa Chauth was after 28 September 2020, date on which petitioner alleges she was thrown out of her matrimonial home. It was also after 8th October 2020, date on which petitioner alleged she returned to matrimonial home when she was threatened and thrown out by the entire family. The Supreme Court said we found absolutely no reason to interfere with invocation of extraordinary power under Section 482 CRPC, which, as rightly held by High Court, secures the ends of justice and puts to naught a criminal proceeding which is clear abuse of process of law.